Good afternoon, everyone. I hope you can hear me. I would like to thank you for joining today's webinar on sex offenders in your congregation, recommendations, and best practices. Our presenter today is Heather Kimmel, General Counsel for United Church of Christ. Heather joined United Church of Christ in 2013 as Associate General Counsel and in 2015 became General Counsel. Prior to joining UCC, Heather was in private practice at two large law firms and also worked for a federal judge. If you have any questions during the presentation, please type them into the chat area on your screen. We will answer as many questions as possible at the end of the presentation, but we do have a large audience today and may not get to all of them. This webinar will be recorded and available later this week on the Insurance Board website at www.insuranceboard.org under Online Learning. With that, I will turn this over to Heather.
Thanks, Monica, and thanks everyone for being here and taking time to pay attention to this important topic. Before we get started, I just have two quick announcements that I need to make to you. And the first one is sort of a disclaimer, and that is that this webinar is not legal advice to the attendees. It does provide general information as well as best practices that have been gleaned from my experience. If you need legal advice for your church's particular situation, you should contact your church's attorney. Questions about insurance coverage should be directed to your insurance company or your agent. And I also want to say a quick thing about the intended audience for this webinar. The intended audience for this webinar includes church pastors, church lay leaders, and those charged by their churches with implementing and enforcing safe conduct and abuse prevention policies. This information really pertains to sex offenders in the congregation. Churches who employ sex offenders should seek legal advice from a qualified employment attorney. Non-church organizations should also seek legal advice from a qualified attorney. So the information that you're going to receive today is going to pertain to sex offenders in the congregation of a church. The integration of sex offenders into a congregation is an issue that has been arising in many faith communities over the past several years. There are many churches who have as part of their mission a policy of welcoming everyone who wants to worship there, regardless of a person's criminal background, political beliefs, race, gender identity, or sexual orientation. Churches should keep in mind that in emphasizing forgiveness and an extravagant welcome, there are others already worshiping in the congregation who are trauma and abuse survivors. The church will likely never know who these congregants are and will need to work hard to remember this silent contingent when it is considering integrating sex offenders into the congregation. Because of this, churches recognize that including people who have a history of abusing others, especially those who do not have an ability to protect themselves, may require some conditions on that inclusion. And this is all to say that we establish policies on integrating sex offenders that include conditions on their welcome because it is good ministry to do so. Because we are ministering to survivors of sexual abuse as well as to sex offenders, the needs of the entire congregation must be taken into account when extending our welcome. The best course of action, of course, is to consider and adopt policies that are related to abuse prevention before an instance of abuse occurs or before you must make a decision about integrating a sex offender. Many of you may be attending today because something has triggered your awareness of these issues, such as knowledge that a sex offender is already worshiping in your congregation. Thank you for taking the time to pay attention to these issues now. Many times you'll hear the advice that you should adopt a policy before you, quote, need it. But I want to reframe that a little bit and say that every church needs a policy, regardless of whether they have had instances of sex abuse or not. So if your church has not adopted a robust safe conduct and abuse prevention policy yet, you should do that. Although this webinar is not specifically designed to help you create a safe conduct and abuse prevention policy, I do want to spend a few moments talking about that. A robust policy is one that is really specifically tailored to your church. So that's not a policy that you download off the internet or someone else's template policy that you adopt. It really needs to be tailored to the needs of your church. It should include requirements for appropriate background checks, reference checks, boundary training, and safe conduct training for your minister. Requirements for your volunteers who work with children that include self-disclosure questions, and we'll talk a little bit more about some of those. Criminal background checks, reference checks, and safe conduct training, and specific provisions related to the safety and protection of children during church activities, such as the requirement that 2 unrelated adults be present during youth activities and written consent from a parent before participating in overnight activities or activities that take place away from the church. An effective policy is also going to define sexual exploitation and sexual harassment. It will clearly indicate a method for reporting complaints about exploitation or harassment, including identifying the appropriate persons who should receive a report and the steps that will be taken to address and resolve the complaint, including requiring abuse to be reported to the state authorities or to the police if necessary. Many online resources, of course, are available to assist you in drafting this policy, including the Insurance Board's Safe Conduct Workbench. That is available online to all churches, regardless of whether you're a member of the Insurance Board program. In your safe conduct and abuse prevention policy, you should include provisions relating to sex offenders, even if you do not know that there is currently a sex offender worshiping in your congregation. A benefit of adopting a policy before you have an instance of misconduct is that it shows that your church is really paying attention to the issue of sexual abuse and recognizes that sexual abuse can and does occur in church settings. A person who is seeking maybe a friendly, trusting environment so that they can more easily victimize others is not going to want to worship in a church that is open and transparent about the problem of sexual abuse. On the other hand, if your church has taken the position that an abuse prevention policy is not necessary, either because no one in your church would ever do anything like that, or because the congregation is small, or because you don't have a lot of children in your congregation, or for whatever reason your church believes that abuse will never happen there, your church is operating under somewhat of a misguided notion. We don't adopt abuse prevention policies because we know that abuse is occurring in our church. We adopt them because it's good ministry to prevent the abuse and to help people feel safe in church. Adopting a policy on your church's integration of sex offenders before you have a sex offender worshiping in your congregation also prevents what we call ad hoc decision making that can be largely driven by some members of the congregation who are either in favor of or against welcoming a particular person for reasons other than reasons that are related to their status as a sex offender. For example, this may be because the sex offender was a longtime member of the congregation before they were convicted, or as a family member of other congregants, or be based on other personal characteristics of the sex offender, such as their age or gender, that may make the person seem non-threatening. Making decisions on these bases may be perceived as offering forgiveness and kindness to the offender, but is really not in the best interest of the entire congregation. So today we're going to cover several topics related to sex offenders, including what is a sex offender and what is the difference between a sex offender and a registered sex offender. How do we know that there is a sex offender in our congregation? What are the elements of an effective sex offender policy? And what about concerns that are related to behavior with youth when the person is not a sex offender? Along the way, we're also going to talk about the rights of churches as private membership organizations to associate with individuals whom it wants to associate and not to associate with those individuals that it determines may be detrimental to the life of the faith community for whatever reason. Let's talk a little bit about who a sex offender is. What we might ordinarily think of when we think of sex offenders is the registered sex offender who has been convicted of a certain type of crime that requires them to register particular information with the state for a specific period of time. Some states may also have particular definitions for the term sex offender. But limiting our discussion to the persons who are required to register under state law excludes individuals who have committed a sex-related offense that has a variety of different consequences or even no consequences at all. A person may be convicted of a sexual offense but not required to register under state law. Or the person may not have registered at all even if they were required to. Also, a person may have been able to plead guilty to a lesser offense. For example, a person may be charged with sexual assault, but pursuant to a plea agreement might be convicted of assault, a crime that does not carry a requirement to register as a sex offender. If we expand our thinking to include all of these individuals, who we may not have an easy way to know that they have committed sex-related crimes, then we can see it really becomes even more important to have a robust safe conduct and abuse prevention policy that requires criminal background checks and self-disclosure questions from church volunteers, as well as provisions designed to avoid circumstances in which opportunity is created for sexual abuse. So churches should be aware in drafting their policies and conducting their background checks for volunteers with youth that relying on sex offender registration websites or even on criminal background checks will not capture the entire universe of people who have been convicted, charged with, or have committed sex-related crimes, because some have never been convicted, charged, or even caught. Additionally, using the terms registered sex offender or convicted sex offender in church policies may unnecessarily restrict the discretion of the individuals who are charged with making decisions about the people who have committed sex-related crimes under their church's policies. So churches should really understand that they're not limited to writing their sex offender policies to apply only to registered sex offenders. And when I talk about policies relating to sex offenders today, I'm talking about policies that should apply to folks that you know have committed sex-related offenses, even if they are not required to register under state law. I do want to talk to you just a little bit more about the category of registered sex offender and what that means. In general, a registered sex offender is a person who is required to register with authorities under state law pursuant to the Adam-Walsh Act, which is a federal law that requires states to establish a sex offender registry with a tiered system that sets the length of time that a person is required to register following a sex offense conviction. There are a number of states that have sex offender registries that do not comply with the Adam-Walsh Act, and some states have refused to comply with it. The consequence of noncompliance for a state is a loss of certain funding, essentially. Our discussion today is not really intended to delve into the laws of any particular jurisdiction, but it can be useful to have a basic understanding of what the sex offender registration requirements are. Whether a person is required to register as a sex offender is ultimately determined by the classification of the offense under state law, and states are really responsible for determining under which tier the violation of their state's laws fall. State laws vary on their implementation of the Adam-Walsh Act. Some states have requirements that are much more strict than other states. While the federal government maintains a website that allows people to search sex offender registries of all states, the information that it returns is maintained by the particular state under that state's particular laws and requirements. So when you are searching the federal sex offender website, you are simply searching the data that the individual states have collected. In general, a sex offender who is required to register under state law registers under one of these tiers, depending upon how the offense is classified. Tier 1 is the least serious classification, and that's a catch-all that can include felonies and misdemeanors. And the length of time that a Tier 1 sex offender is required to register is 15 years. Tier 2 are felonies that include child pornography, child prostitution, use of a minor in a sexual performance, and sexual contact with a minor. And that carries a requirement that the person register for 25 years. Tier 3 includes sexual acts that involve force or threats, sex acts with a person who is unconscious or unable to decline to participate, sexual acts with a child under 12, and non-parental kidnapping of a minor. And that registration requirement is for life. So remember that sex offender registries are only as good as the information that goes into them. Penalties for not registering or updating information varies by state. Community notification policies also vary by state. And a community notification is when people who live within a certain radius are informed when a sex offender moves into their community. This is all to say that you should definitely check sex offender registration websites, but that these websites are not a substitute for conducting a criminal background check and requiring self-disclosure questions for your volunteers who are working with youth. We're going to talk a little bit now about what an effective sex offender policy looks like. And an effective sex offender integration policy will consist of both provisions in your abuse prevention policy that address sex offenders and also an agreement with the sex offender in which the sex offender agrees to disclose certain information and be limited and monitored at church and during church activities. This is also a good time to mention that the abuse prevention policy will not be effective if people are unaware that you have one. While the congregation might be aware of the policy when a committee is first appointed to draft it and then it is presented to the congregation, 5 years later, memories will have faded. Consider posting your abuse prevention policy in a public area and in areas where children's ministry takes place. Have copies available for distribution, and consider putting it on your website if you have one. While this webinar does not address all of the elements of an effective abuse prevention policy, a couple of provisions are key to think about when we are considering adopting policies relating to sex offenders. These are not all of the provisions that are necessary for an effective policy, but form the basis for it. You are going to want to develop your own language that is consistent with your church's policies. Remember, we talked in the very beginning that an effective abuse prevention policy is one that is tailored to the needs of your church. First, the church should state that it prioritizes the protection of children and vulnerable individuals. Second, the church should state that it will take steps to limit or deny access to the church if church leadership has concerns about a person's behavior. This provision is broad enough to show that church leaders will address concerns that may be raised, even if there is no conviction for a sex-related crime. A common question that is raised by churches is, can we do that? And the answer is yes, you can do that. Churches should be aware that they have the right to exclude a person from their property, from worship, and even from membership for any reason or no reason. Churches are protected in their membership by the First Amendment. While churches have this right under the law, a church should also be clear in its policies and bylaws that it has the discretion to exclude any person. And this is not because we do not want to worship with those who are different than us, but is to ensure a safe environment for all. And this applies to any behavior that threatens the safety of the church setting, not just behavior that is sexual in nature. Sometimes churches ask who is responsible for making these decisions. Is it the pastor? Is it the president? Is it the moderator? And really, the answer to that depends upon the governance structure, the size of your church, and the policies that you currently have in place. It will likely be the individuals who are charged with making decisions under the abuse prevention policy. In small churches, this may be the pastor and one or two lay leaders that are charged with decision making on abuse prevention issues. In larger churches, there might be a safe conduct committee or other committee that is specially appointed to that task. These are decisions that the church is going to have to make when it is drafting or updating its abuse prevention policies. And similarly, the drafting and approval of any policy is going to be subject to your church's particular governance structure and its governing documents. Your policy should, though, clearly state who is responsible for hearing abuse prevention concerns and for making these decisions. Records should be kept of the decisions that are made and the reasons for those decisions. Your abuse prevention policy should also require a criminal background check, reference checks, and self-disclosure questions for volunteers with youth. And as I stated in the beginning, this webinar addresses volunteers and it does not address employees. So if you need advice concerning what to ask of your employees in a pre-employment screening or in an interview process, you should consult with an experienced employment attorney for that. For criminal background checks for volunteers, you also need to consider the address history of the volunteer. Checking in the current state is not going to be sufficient if the person has moved there recently. There are many, many companies who will do criminal background checks. The best ones are the ones that will physically send someone to search the records in the county in which the person has lived and not rely solely on online databases, because some of those county databases are only updated periodically. I know that the insurance board has a relationship with Presidium, and that organization offers some discounts to member churches on background checks. Your volunteers should fill out an application that requires reference checks and self-disclosure questions. Please be sure to check the references, and the references should not be related to the prospective volunteer. I'm often asked about, when I recommend self-disclosure questions, what questions should we ask? And in terms of self-disclosure questions on your volunteer application, you can ask whether the person has been convicted or adjudicated delinquent of any crime relating to conduct with children, including but not limited to child pornography, physical abuse, or sexual abuse. You can ask whether the person has been adjudged liable for civil penalties or damages involving physical or sexual abuse of children. You can ask whether the person has been convicted or adjudicated delinquent of any sex-related crime. And finally, you should ask whether there's any fact or circumstance involving the volunteer's background that would call into question the volunteer being entrusted with the responsibilities of the position that they're applying for. Churches do sometimes say that longtime volunteers will not want to answer these questions or will really be offended by these questions. In my experience, the people who are longtime volunteers truly care for the well-being of our children, and they understand why the questions are being asked. And that should really be the focus of these questions. They are not to embarrass or harass people, but they are to have a policy that is going to apply across the board to the brand new volunteer, as well as to the youth group leader who has been doing this for 10 years. And while it's great to ask these questions, churches need to really pay attention to the process and to the answers that they receive. So if your policy is that youth volunteers must undergo background checks, then you cannot accept as a volunteer a person who asks at the last moment whether they can accompany their child to a church camp as a chaperone. If there is not time for an application to be completed, a background check to be conducted, and the information to be reviewed. So sometimes these are hard conversations to have, but if you have a policy in place, it becomes a much easier conversation to say, I'm sorry, but everyone has to comply with our policy. Finally, your abuse prevention policy should require persons who have been convicted of sex-related crimes, including child pornography, to notify church leadership of their presence in worship. Some model policies may use the term registered sex offender for this. As we discussed before, that term may not adequately capture all convictions for sex-related crimes. So this policy provision effectively requires individuals who have been convicted of sex-related crimes to self-disclose their status to particular church leaders, whoever that may be under your church's policy. Sometimes people wonder how effective this provision is. And this provision really has two purposes. And the first is to do exactly what it says, which is to identify individuals who have been convicted of sex-related crimes. And the second is to show that the church is really paying attention to these issues. People who are honest and aware of the policy will come forward. When a sex offender has been identified in the congregation, the church leaders charged with the responsibility should then follow up with a limited access agreement for the offender, and that is what we are going to talk about next. I mentioned before that we want to avoid making decisions about sex offenders in our congregation on an ad hoc basis that may be driven by personal relationship of the individual with members of the congregation or certain personal characteristics of the offender that are not related to the offense. So what we need is a process that takes into account the right factors, which include but are not limited to the nature of the offense, the risk of reoffending, the offender's ability and willingness of the church to accommodate legal restriction on a sex offender's participation in certain activities, and the offender's agreement to have conditions placed on their participation in worship. One of the key elements of such an agreement is that the offender agrees to provide, and the designated leaders at the church review, certain information so that the church has a basis to assess the risk of the offender worshiping with the congregation. This information should include a statement from the court as to the nature of the conviction, a risk assessment from a qualified therapist, and a report from a certified treatment provider indicating the recidivism risk for the offender. Now, I have had churches say that number 3, oh, there is no one who will give those, and that's a ridiculous thing to ask for. So at the end of this presentation, there's a slide that has resources on it, including the Association for the Treatment of Sexual Abusers, and that website does have a search where you can get to a certified treatment provider who will do that. So I have included that information at the end of the presentation. The offender should also agree to allow the church leaders to have a conversation with the parole or probation officer as to any particular restrictions on an offender's activities. Sometimes there are particular restrictions on an offender's activities that may make it not possible for that person to participate in worship, depending on how worship is set up at your church, and we want to be careful about complying with those as well. Another key piece to effectively integrating a sex offender into your congregation and to continuing to minister to those who are survivors of sexual abuse, as well as to parents and guardians of children and other vulnerable members, is that the offender should agree to disclose their status to the congregation. This is not an opportunity for the offender to offer excuses, an explanation, or details of their criminal behavior, but simply to inform the congregation that they have been convicted of a sex-related crime. This must occur before the offender is permitted to attend worship or church activities. The best practice is for the offender to disclose their status to the congregation in person at the beginning of worship to allow for a visual identification, and for church leadership to follow up with congregants who are not in attendance and with congregants who begin to attend subsequent to the offender's disclosure. When church leadership has information that a parent or other caretaker needs to make their own determination about the safety of their child, or that a congregant needs to make a decision about their own safety, The church leadership can't ethically withhold that information from the congregant. The congregants get to make their own decisions about the safety of their children. So there's a trust between a church and its congregants that will be broken if church leadership knows that a sex offender is worshiping in the congregation, does not tell the congregation, and the congregation finds out that the church knew and did not tell anyone. If a church decides to implement a policy of limiting a sex offender's access, but does not require the offender to agree to disclose, that church is essentially curtailing the right of a parent to make decisions about their child's safety and is taking on that task itself. This really promotes a serious power imbalance in the church. It puts the church in the business of secret keeping and not in a position to promote transparency and safe conduct. Some churches are worried that the disclosure of an offender's status is an invasion of privacy, or that it could lead to a defamation claim or some other legal claim. The way to avoid this is for the offender to agree to disclose the status as a condition of participating in the life of the congregation. If the congregant does not agree, then the congregant may not attend worship or church activities. Some churches have suggested that only a small committee of folks in the church should know, excluding the pastor, because they are worried that the congregation and the pastor might treat an offender differently if they know that that person is an offender. I cannot recommend this course of action because it substitutes the judgment of the committee for the judgment of the congregants, and it withholds important information that congregants need to know that is related to their safety and the safety of their children. Some churches also suggest that a small committee be informed and then offer to make that information known to congregants upon the request of the congregants, so that members of the congregation would know that information is available, but could choose to remain ignorant. I also can't recommend this course of action because churches can't hold secret information that congregants need to know just because those congregants may find it hard to hear. It is not the church's responsibility to shield congregants from the information that they need to know. The limited access agreement should also clearly state that the offender must avoid contact with children at church and at church-related activities, should not volunteer for youth activities, and must remain in the presence of a designated person at all times while on church property or at church-related activities. The church leaders should designate several individuals who are not related or friends with the offender to accompany the offender at all times. These individuals should be named in the agreement and should be thoroughly familiar with the offender's history. Finally, the offender, the pastor, the church leaders, and the persons appointed to accompany the offender should meet on a regular basis to monitor the implementation of the agreement, which should stay in place for the duration of the offender's attendance. While we should be conducting criminal background checks on our volunteers that work with youth, ordinarily a church is not going to be conducting background checks on potential new congregants or on existing congregants. And even if your abuse prevention and safe conduct policy is well publicized, not everyone may know about it. So how do we become aware that there is a sex offender worshiping in our congregation? That can happen many ways. One of the ways that triggers the most telephone calls to my office is that the church lives through the conviction of an existing member of the church. Another way is that a potential member may self-disclose, or another congregant may disclose the information, or the church may receive an anonymous phone call, letter, or email. I often hear that a concern has been raised by someone else that a person is or may be a sex offender, but the church isn't sure what to do or how to verify the information. And the most practical way to handle this is for the designated church leaders to have a private conversation with both the person who's raising the concern and the person who may be the offender to determine whether the information is legitimate and to make the offender aware of the congregation's policy on individuals who have been convicted of sex-related crimes. Now, the church may also receive information that is more subtle than this that raises concerns. Someone may tell church leadership that a particular individual resigned from their job because of concerns raised about the way they interacted with children. Or parents may express concerns over the way a particular church volunteer or employee is relating to their child. These concerns should be brought through the safe conduct and abuse prevention policy and processed appropriately. Outcomes may include having that person sign a limited access agreement, removing them from service as a church volunteer, or even terminating their membership if the behavior is not able to be controlled. However information comes to the attention of a church, one thing that a church cannot do is ignore the information or put artificial constraints on how it deals with the information. And what I mean by that is, for example, if a church receives an anonymous tip, it cannot decide that it is not going to investigate the tip simply because it's anonymous. So focusing on the protection of children and vulnerable individuals in our congregations is the right thing to do here. For the policy to be most effective, the church leaders need to notify the offender about the policy as soon as the church is aware that there is an offender in their midst. Likewise, if a church develops and adopts a new policy, hang on, there we go. Sorry, I don't know what happened. That slide skipped ahead. If the church adopts a new policy that applies to particular longtime church members, those members should be required to comply with the policy immediately. And there I go with the jumping. I don't know why the slides are jumping ahead. See if we can get them back. All right. So the policy, well, I don't know what's happening there, but we'll talk about that next. The policy is not a secret, and the policy should also not be viewed as a detractor from your church, and instead it should be seen as positive. The church should be serious about the protection of youth and vulnerable individuals and transparent about its efforts to promote that protection. I do want to say a few words about some legal considerations, and the first is to do with the clergy penitent privilege. Sometimes pastors say that they cannot do anything with information that they receive about a member of their congregation being convicted of a sex-related crime or concerns about their behavior toward children because it was told to them confidentially and they cannot violate the clergy penitent privilege. So I just want to clarify a couple of things there. And sometimes congregants will tell me this too, because I think that most ministers do understand the clergy penitent privilege a little better, but sometimes church members don't understand it. The clergy penitent privilege, for which every state has a completely different statute, is a rule of evidence that applies to testimony that's given during a legal proceeding or during a deposition. It forbids a pastor from testifying without the permission of the person confessing the information to the pastor, and that is all. There's no law that prevents the pastor from telling the individual that they are subject to the abuse prevention policy and from notifying appropriate church leaders that they need to proceed under the policy. And there are many, many, many other limitations on the clergy penitent privilege that are sort of beyond the scope of this webinar. Sometimes pastors will tell me also that they have a pastoral ethic of confidentiality that they must uphold, or again, congregants, concerned congregants will come to me saying that the pastor has to keep this information confidential. Well, of course, in the first instance, a conviction is not something that's confidential. And even if there's no conviction, the pastoral ethic of confidentiality really should not be used as a wall to protect people from the consequences of their own behavior. And it shouldn't extend to keeping secrets that are going to harm others. I'm addressing legal liability for churches last because we have safe church and abuse prevention policies and limited access agreements because they're good ministry and because they're the right thing to do for our congregations and not primarily to avoid legal liability. But it shouldn't come as a big surprise that churches face legal liability for sex abuse acts that are committed by employees or volunteers during church or church-related activities, regardless of whether the church knows whether a person previously committed sex-related crimes. That risk is going to increase if the church does know that the abuser previously committed abuse. These legal claims can be brought under a number of different theories that are based on negligence and breach of particular duties. You can deal with legal risk in a number of ways. In a church congregation, the risk really can't be completely eliminated. It can be managed and it can be reduced by good policies that are effectively implemented and monitored, by consistent background and reference checks for volunteers, and by appropriate disclosures to the congregation. Some of the financial risk that we experience in this area can be transferred to insurance companies in some instances, but reputational risk is a type of risk that cannot be transferred. So that is why we want to pay attention to these issues. Insurance coverage also might be affected in certain instances if a church knows that a person previously committed abuse and that person is a member of the congregation. You'll want to consult your insurer for what the limitations are under your policy about coverage for sexual molestation claims. So this is my last slide, and after this slide, I'll be happy to have Monica read the questions. I have just a couple of different resources here. The first one is the Federal Sex Offender Registry. This is the registry that compiles all of the information that it pulls from states' registered sex offender databases. You can go here and you can do a search on a name, you can do a search on an area, an address, and pull out the information that that state gives to the federal government. So the federal government isn't really adding anything to this except making it available in one place. The second link is to the Insurance Board Safe Conduct Workbench. And that is a collection of resources that churches can use to draft abuse prevention policies. I think there's a draft limited access agreement. All of these need to be tailored to your church's particular needs. And finally, there's the Association for the Treatment of Sexual Abusers, for the Certified Treatment Provider Search, and that's at apsa.com. And that actually is a good website in general if you're dealing with some of these issues. It has information on there about the risk of recidivism and different things that we know about pedophiles and how they prey on children. So that is the conclusion of the information that I wanted to present, and I am happy to take questions now.
Thank you, Heather. And we do have a few questions that came in. I wanted to let everyone know that we will have the slides up and available, I would imagine, by tomorrow afternoon, along with this recorded presentation for anyone that would want to access that information. So on to our questions. First question we have, someone asks, must the offender self-disclose at the start of worship every Sunday?
No, I don't think that that's realistic. I think that a one-time disclosure is appropriate, and then the congregation, the leaders of the congregation, should follow up with people who were not in worship that day and with congregants who join later. Some of the ways that churches have handled it is to have the offender self-disclose to allow for that visual identification, as well as send a letter to the membership. And so that way we're not worrying about who was and who was not in church that day. And then as new members come in, those members are informed as well. So no, I don't think it's necessary to self-disclose every week.
Okay. Next question, someone's asking, so this policy should be separate from a safe church policy?
So the Safe Church and Abuse Prevention Policy should contain those policy provisions that I went over about sex offenders, but the limited access agreement is separate from the abuse prevention policy.
Okay, next question. How would you make it known that offenders are required to self-disclose? Would you put it in the weekly announcements in the bulletin?
I would not do that. What I would concentrate on is promoting the abuse prevention and safe conduct policy, which would have that requirement in there. So maybe a reminder maybe have that published, have copies of it available, keep it in the children's ministry area. And then some churches do when Sunday school starts up in the fall, or the new program starts, does a reminder of that, perhaps from the pulpit or in other ways, or sends it to all of the parents. There are many ways that information about whether a sex offender is worshiping in your congregation can come to the pulpit. Just having the sex abuse policy, I agree. If not everyone knows about it, it's not going to be effective. So I would do everything I can to promote that. I guess if people wanted to put it in their bulletin, they could, but I would maybe promote the abuse prevention policy as a whole so that people are aware of the provisions in it.
Okay, great. Next question. Can potential members be required to pay for background checks?
So I think this question is directed to background checking all new members, and that I want to be clear, I'm not saying that I think that all new members of churches should be background checked unless there's a reason for that. But certainly all new members should be aware of all the policies of the church and should read them. And if the church adopts a policy saying that we're going to background check every new member, certainly new members can be required to pay for their own background checks.
Okay, next question. Should background checks be repeated over time? And if so, how often is recommended?
So this is a good question. There isn't really, there's not really a quote unquote industry standard for that because it does change over time. So one of the things that you can do in your volunteer application is you can include a provision that states if any of the information that you've disclosed here or your criminal background check changes, you need to let us know, immediately, which that's only going to be effective if people pay attention to that. But a good rule of thumb would be every 3 years for a background check to be repeated.
Great. Next question, and they're rolling in. We've got a lot of them here. How do these recommendations apply to someone who has committed sexual harassment in a church setting but has not been legally charged or convicted?
Okay, so sexual harassment is a little bit different than what we are talking about now. So let me address that in two different ways, and I'll try not to go on too long because sexual harassment isn't really the focus of this webinar. So sexual harassment is a legal term of art, and it can be quid pro quo sexual harassment, which means essentially asking people for sexual favors in return for not firing them or for giving them a job benefit, like a promotion. And then it can also be a hostile work environment, meaning that the sexual harassment is so pervasive it creates a hostile work environment. And that is generally an employer-employee issue. And so maybe what the person is referring to, and I don't know, is that if you have been, if a person has engaged in sexual exploitation but has not been convicted of it, and if the church is aware of it, they should address it with that person and have them sign a limited access agreement if the church feels that that is appropriate.
Okay, next question. Are there any policies for persons who have been abusers of adults or elders?
I think that a sex offender agreement in terms of people who have been abusers of adults or elders the same policy can definitely apply because a person who's convicted of a sex-related crime, we're not just talking about minors or because you can be a registered sex offender because you committed a sex offense against another adult. So I don't think any of these policies, like the limited access agreement, have to apply only to those who have been convicted of sex-related crimes with children. I definitely think they can apply to those who have been convicted of sex-related crimes with adults or those who have committed sex-related crimes with adults. But the focus of the limited access agreement is the protection of children and vulnerable members. So if a church has a particular concern in its limited access agreement about we don't want this person to go to particular elder care ministries or something like that, they can certainly limit that person's participation as far as that goes.
Okay. Next, and this is a good question, what if an affiliated group, like a church-sponsored scout group, has a known sex offender connected to their group, but not a church member?
It's a really good question. So the church, as a church, like I said, it can exclude anyone from its property that it does not want to have on its property. And so that is probably an arrangement that you're going to have to talk about with that group. Say that you have policies about that and you need to get in place a policy for that particular person. And if the group's policy is not consistent with the church's policy, perhaps that group should find a different place to hold its meeting.
Okay, the next question, it says, what about guests on any particular Sunday? How would they know? I'm assuming that means how would they know that there are offenders in the congregation? I'm not real sure. How would you take that question?
So I would take it two different ways. I would take it as, number one, how would a visiting family know who the sex offenders are in the congregation? And then I would also take it another way as, what if we have a guest who is a sex offender? How would that person know what our policy is? And really, there's no good answer to that, because if you have a family who's just visiting for one time, is your first instinct to put a copy of the Safe Church policy in their hand and hand them the letter that says this person is a sex offender, welcome to our church? That may be a conversation that the pastor needs to have with that family, if they are coming to church on a regular basis. The same goes with the person who starts showing up for worship. That would be part of the welcome of that person, is to say, thank you for coming to worship. We have these policies. Please read them and review them. If that person starts attending worship on a regular basis.
Okay.
More than once is what I would say.
Someone asked, does having this policy affect membership and scare some people away?
I think it would scare away people who are looking for an environment where they have easy access to children and that people are not paying attention to these issues. That is who it's going to scare away.
Okay. Is it acceptable for the church leadership to disclose the presence of a registered sex offender with the offender's permission?
I assume this means instead of the person self-disclosing. And, if that's how the church wants to handle it, I think you still need to allow for that visual identification, so that person would have to be pointed out.
If a registered offender is no longer on parole, is the recommendation to contact their parole officer waived? If so, how else should that information be received?
You can still have a conversation with that person's parole officer, even if they were not. I'm not sure how the information is coming to them that person is no longer on parole, but that is going to need to be verified somehow, and I would start with whoever their parole officer was.
Next question, does it make sense to avoid all these issues by simply denying access to all sex offenders?
Well, I think that would be contrary to many of our churches' policy of providing a welcome to all people, even if conditions need to be placed on that welcome. Certainly, in some instances, some churches may choose to do that. I am not making a recommendation on that one way or the other.
Okay. Next question, what if your church is renting its facilities to another church? They use your facilities and have a different worship time. Do the same disclosure steps apply?
It's going to be these apply to the church. So I don't think that the church who owns the building in which another church is worshiping has that sort of relationship where it can't have that person as a member because it's a member of the other church. What I would recommend is, if there's a facilities use agreement in place, that those issues be addressed in the facilities use agreement. For example, some churches have rent their facilities out to other organizations, and they have a facilities use agreement that says that any groups who are using our property or our facilities have to comply with XYZ. And so that can be one of the provisions. I don't know that unless there's two groups who are using it at the same time, whether that becomes an issue or not.
Okay. Next question. Our denomination uses a version of a limited access agreement that you describe, but we continually get questions about whether the agreement could ever expire or be removed after a period of time, or the obligations of particular provisions could be lessened. What are your thoughts?
My recommendation is that the agreement stay in place for the duration of the person's participation in the life of the faith community.
Okay. In terms of disclosure to the congregation, does your recommendation hold for levels that are not publicly searchable in our state?
I'm not sure what that question means. I'm going to take it as the person has been convicted of a sex-related offense that either doesn't require registration or that the public is not entitled to know about. And my recommendation is that if a congregation knows about that person, that that person be subject to a limited access agreement.
Okay. That is just about all of the questions. We got through those pretty quick. If anyone has any further follow-up questions, if you want to type them in real quick and we can get them answered, we've got a couple minutes left. But I would like to take this opportunity. Oh, here's one that came in. Would it apply to those who have been offenders of adults?
Yes.
I think you covered that earlier. So you were talking about anyone that was convicted of a sexual offense, correct?
Right. Yes, because if you, and I'll just go back to this real quick. I won't go back to the slide, but if you look at the requirements for registering as a sex offender, those are not requirements that relate strictly to the abuse of children. I mean, those can relate to the abuse of adults, rape of an adult, sexual acts involving force or threats, acts with a person who's unconscious or unable to decline to participate, those sorts of things. But our focus for protection is on our children. But that's also why we have the disclosure requirement, right? Because there may be adults in the congregation who need to know that information to protect themselves.
Um, Someone asks if you could please repeat the answer about background checks for all members and new members.
Okay, so what I said was I am not promoting a policy of background checking all potential members of churches. I don't think that that is necessary. But what I did say is if a church has a policy, has decided to adopt a policy of background checking all of its new members and potential members, that the person could be made to pay for that background check themselves.
And here's one I somehow skipped over earlier. I apologize. Someone asked, is the limited access agreement a sample document in your policy appendix, or are they created individually on a case-by-case basis? Do they contain specific information like Fred Smith is a Tier 1 offender, etc.?
So I don't necessarily think that it needs to be a sample document in a policy appendix. I think it can just be for the use of whatever committee or group of individuals that is charged with responsibility for making decisions about sex offenders in the congregation. I don't, in my recommendation is that there not be a lot of customization in terms of whether that person is allowed to have access to children or whether that person can volunteer for youth activities and those sorts of things. The customization is going to be what relates to your church. If your church doesn't have a coffee hour, you're going to take, the coffee hour provision out. If your church doesn't have has a trunk or treat that it invites all members to participate in, you're probably going to want to say you can't participate in trunk or treat. So those sorts of things will be customized. So I don't see a lot of customization from individual to individual, because what we're doing here is we're not making judgments about individuals on an individual basis, right? We're having a policy that's going to apply to people who have been convicted of sex-related crimes, and those carry a certain risk with them. And so here is what is going to apply to you as a member of our congregation or as a person who's worshiping in our faith community. And this is what's going, these are the conditions that we need to place on your integration.
Okay. Quick question, Heather. We are coming up on 3 o'clock. I have about another 6 or 7 questions that came in. Do you have flexibility in your schedule that you could stay on for a few more minutes to answer these, or I can take the questions down and follow up with people via email later?
Yeah, I can stay on for about 5 more minutes. That would be fine.
Oh, Great. We'll try to get through these. The question I had, if a person's requirement to register expires, does the limited access agreement also expire at the same time?
No, I don't think we need to make decisions about our ministry based on what the person is subject to under the law. I think the agreement stays in place for the duration of that person's participation in our faith community.
Next question, what questions should church leadership be asking of a sex offender who wants to attend a church retreat at another location?
So I'm a little bit confused by the question, but I would assume it's an adult retreat. So I would maybe ask for the same sort of information that would be asked for the limited access agreement. If you're a sex offender, what is the nature of the conviction? What is the recidivism risk? Because honestly, if it's a situation that is going to, from the facts and circumstances of the conviction that mirror sort of the facts and circumstances of the retreat, that's going to be a decision that the church is going to have to make to say, we're not comfortable with that. So that's information that the church is going to need to make those decisions. So I would say ask whatever questions it needs to be comfortable with its decision.
Okay. If someone's conviction happened prior to the establishment of the registry and the person is long past any restrictions, is there a different approach to the limited access agreement?
Can you repeat the question? I might have misheard it.
If someone's conviction happened prior to the establishment of the registry and this person is long past any restrictions, is there a different approach to the limited access agreement?
I don't think so.
Are there roles other than children and youth volunteers that you would recommend for background check?
So certainly you're going to background check, this gets into employees, but definitely all of your employees. If you have people, and this is sort of beyond the scope of this webinar, but I would recommend that you background check any people who are engaged in transporting others. So because usually those people can't transport themselves for various reasons. So if you have a driver, you're gonna background check them anyway for their driving record, right? So just do a criminal background check on them as well. Any individuals who may be involved in elder care or other adults with disabilities ministries, and also people, again, a little bit beyond the scope of this webinar, but people who are engaged in providing volunteer services to your church for financial issues, such as your church treasurer or similar positions like that.
Okay, the next question is one I can actually answer. Someone asked if the presentation slides could be emailed to the attendees, and I will say yes. If you, in the chat, it's private, coming only to the presenters. If you want to just send me your email address, I will send the slides out to you in PDF format via email.
Okay, I do want to say one thing about the slides. Most of this presentation was verbal, so if I would really recommend that whoever is receiving these slides also listen to the full presentation and not just rely on what is in the slides.
Very good point, yes. Next question, what about someone who has disclosed that they were convicted of having sex in public 20 years ago?
These are decisions that churches may have to make pursuant to the policies that they have in place. The questions about these very particular circumstances may warrant a bit of a different approach.
And someone is asking, does this apply to a regularly attending non-member who is not a volunteer?
Yes, absolutely. Yeah, whether a person is a member or not, doesn't really matter, but this is an agreement that they would enter into because they want to participate in the life of the church.
Okay. Are there any provisions for those convicted as minors? Are those records even public?
Those records are generally not, those who have been adjudicated delinquent is generally not public. I'm not sure if jurisdictions vary on those or not. But you can still ask the question in the self-disclosure questions. And some offenses for which minors are adjudicated delinquent, I do believe carry a requirement to register as a sex offender because those requirements can apply to minors as well. So that's a little bit of a wrinkle there. So that's information that would be available.
Okay, we are now at the end of our time. I squeezed those extra 5 minutes out of you, Heather.
Thank
Thank you
you.
very much.
Thank you all for
I
coming and for paying attention to these issues. I really appreciate it. Thanks for inviting me.
Yes, definitely. And I want to thank you for providing this great information to everyone here. There's been a lot of interaction going on, and I think people probably found a lot of value in it. So I just want to remind everyone again, we will have this recording up on our website, should be by tomorrow afternoon. We will also have a link to the PowerPoint presentation available in PDF format. Please note what Heather said earlier, though, that whoever views these slides should also listen to the recording. So again, thank you all for joining us today, and I hope that you did find value in this presentation, and we look forward to your participation in future webinars. I would like to wish everyone a good day, and I will get those emails out. I've gotten quite a few, and I will get these slides emailed out to you as well. Thank you.
Thank you. Bye-bye.
Bye-bye.